Dear colleagues and friends, good to see you, members of the organizing team, speakers, and the 76 attendees. With Margaret, Burkhardt, and Enrique, I'm happy to welcome you to this new CPLJ webinar, the 8th one, if I'm right. We will have the privilege to hear two outstanding and prominent scholars, John Dashako first, Sami Bostanji secondly. After East Asia and Latin America, which were the topics of the 7th webinar, we continue today our comparative overview by directing our eyes towards Africa. I'm particularly delighted to moderate this session, which will take place partly in English, partly in French, thanks to the possible intervention of Mr. Spiropoulos for the first part and the permanent one of Mr. Huyet for the second part. I thank them a lot. Avec Margaret, Burkhardt et Eric, je suis heureux de vous accueillir à ce nouveau webinaire du CPLJ, le 8e, si je ne me trompe pas. Nous avons aujourd'hui le privilège d'entendre deux universitaires exceptionnels et éminents, John Dashako d'abord, Sami Bostanji ensuite, et après l'Asie de l'Est et l'Amérique latine, qui étaient les thèmes du 7e webinaire, nous poursuivons aujourd'hui notre tour d'horizon comparatif en dirigeant notre regard vers l'Afrique. Je suis particulièrement ravi d'animer cette session qui se déroulera pour partie en anglais, pour partie en français, grâce à l'intervention éventuelle de M. Spiropoulos pour la première partie et celle permanente de M. Huyet pour la deuxième partie. Je les en remercie vivement. Africa is a fascinating continent, but a continent that is not the best known from a legal point of view. It is fascinating because of the great diversity of the legal system that make it up and which combined differently depending on the countries, elements of common law, of continental law, of traditional customary law, and of religious law. It is also a continent where the phenomenon of regionalization of law has developed through several supranational or intergovernmental organizations for economic and legal integration. The OADA, Organization for the Harmonization of Business Law in Africa, is undoubtedly the most successful example, but it's not the only one. L'Afrique est un continent fascinant, mais un continent qui n'est pas le plus connu du point de vue juridique. L'Afrique fascine. L'Afrique fascine par la grande diversité des systèmes juridiques qui la composent et qui combinent différemment selon les pays des éléments de common law, des éléments de droit continental, de droit coutumier traditionnel et de droit religieux. C'est aussi un continent où le phénomène de régionalisation du droit s'est développé à travers plusieurs organisations supranationales ou intergouvernementales d'intégration économique et juridique. L'OADA, l'Organisation pour l'harmonisation du droit des affaires en Afrique, est sans doute l'exemple le plus abouti de cette régionalisation, mais ce n'est pas le seul. As usual, this webinar will alternate presentations and discussion. I kindly ask the speakers to scrupulously respect their speaking time in order to allow fruitful discussion. Alors, comme à l'accoutumée, ce webinaire alternera présentation et échange, et je demande gentiment aux intervenants de bien vouloir respecter scrupuleusement leur temps de parole afin de permettre une discussion fructueuse. The OADA sub-region will open our webinar with the first contribution devoted to the harmonization of simplified debt recovery procedures and presented by John Dashako. Professor Dashako teaches at the University of Yaoundé 2 the political capital of Cameroon. This position is particularly interesting because Cameroon is a country of mixed law. So I would dare to say that a comparison is second nature to him. La sous-région OHADA ouvrira notre webinaire avec la première contribution consacrée à l'harmonisation des procédures simplifiées de recouvrement de créances qui sera présentée par John Dachako. Le professeur Dachako est professeur à l'université de Yaoundé 2, qui est la capitale politique du Cameroun. Et cette situation est particulièrement intéressante car le Cameroun, vous savez, est un pays de droit mixte. J'oserais alors dire que la comparaison est pour lui une seconde nature. It's my pleasure to give now the floor to John for 30 minutes. Eh bien, je suis heureux maintenant de lui donner la parole pour 30 minutes. C'est à vous, chers collègues.
The presentation will be on the harmonization of simplified debt recovery procedures in the OHADA sub-region, and I will insist on, or I should say, I will make an appraisal of the injunction, the injonction de payer procedure under the Uniform Act, OHADA Uniform Act, and the common law on defended list procedure. And this is important because the rules on simplified recovery procedure, that is before the OHADA Treaty and the Uniform Act on simplified recovery procedure, were before this Uniform Act different or contained in different instruments in the OHADA member states. And of course, these instruments were very much influenced by what obtained in France during the colonial administration. And it is common knowledge that the majority of these countries were held by England and France after the defeat of the Germans during the First World War. And of course, like I said earlier, the majority of these instruments were, of course, influenced by the legislation in France, but for Senegal, the Republic of Senegal, and the Republic of Congo, which enacted their own instruments on civil procedure after they acceded to independence in the 1960s. But of course, both pieces of legislation equally had provisions on the injonction de payer, that is a simplified debt recovery procedure. And of course, in the English-speaking parts of Cameroon, common law jurisdiction, a form of summary trial, the undefended list procedure, was applicable. And this is by dint of the fact that the English-speaking regions of Cameroon were held by England, first as League of Nations mandate territory after the defeat of Germany during the First World War, and later as a United Nations Trust territory. And of course, England joined the English parts of Cameroon, then the southern Cameroon, to Nigeria to be administered as one territory, for which laws were passed. And of course, these laws were naturally applicable in the English-speaking regions of Cameroon. These laws we may find in the slide we have ahead of us. But then in the other French-speaking parts of, or the other French-speaking countries of the other sub-region, but for Senegal and the Republic of Congo, of course, the law applicable as far as simplified recovery procedure is concerned was the French civil the French law of 1804, which of course was adopted by these countries and continued to be enforced even after they acceded independence in the early 60s. And because these laws were found in different instruments, of course, it was not very good because it did not provide judicial security. and the OHADA member states, of course, because OHADA had been created, thought it wise that one instrument should be elaborated which took into consideration the specificities of these countries, and of course would facilitate or would be a facilitator to judicial security, and of course which would equally encourage or will encourage foreign direct investment. And that is why the Uniform Act on Simplified Recovery Procedure and measures of enforcement of judgment was elaborated. But the Uniform Act contained quite a lot, but amongst which was the injonction de paix, which we may literally translate as an injunction or an order, a mandatory order to pay. And of course, this became applicable on the entire, or in the entire 17 member states of OHADA. Of course, the community legislator then introduced this procedure for the member states, but this procedure was somehow similar, even though not identical, to what obtained under the common law jurisdictions in Cameroon. That is the undefended list procedure. So our intention here is to look at these two procedures. How do they differ from each other? But we shall not limit our discussion to the two procedures, because we shall find as we progress that the Uniform Act itself on certain matters refer what has to be done to the legislation of the different member states. So here we have a situation where the Uniform Act has made provisions for the procedure, but at the same time, that is shared with the member states or the legislation of the member states, because sometimes resort is made to this for the application and the enforcement even of the decisions of the court. And of course, so if we have to understand what has gone on and if there has been an improvement on the procedures that existed in the member states even before the Uniform Act, which of course was elaborated and entered into force in 1998, we are first to make an inventory of the legislation that was applicable in the different member states, and of course before the elaboration of the Uniform Act, because that will help us understand, it will facilitate our understanding of what the injonction de paix procedure is all about, and if at all, or if it did, or if it is an improvement upon the undefended list procedure that was applicable in the common law jurisdictions. So like we said earlier, of course, the majority of these countries were held by France. So the laws in these countries, of course, were influenced by legislation in France. And as early as 1937, of course, the French had instituted a summary procedure known as a summary judgment procedure known as the injonction de paix. And of course, this is what the majority of, this is what the OHADA legislator has taken into consideration, or has taken into consideration in the elaboration of the Uniform Act. The procedure was limited to commercial matters of limited amounts, of course, but later it was extended to civil claims and then to commercial and civil claims without limitation to the amount of the claim. Where the contents of the Uniform Act, or what were the contents of the local legislation, national legislation before the Uniform Act? That is as far as the injonction de paix is concerned. Of course, if we look at Senegal, put it if we look at the injonction de payer under Senegalese law, we found that the debts that were capable of recovery under the injonction de payer procedure were limited to debts that were not more than 1 million francs CFA, and of course debts that resulted from the acceptance of a bill of exchange promissory notes, and it was almost the same under the legislation of the Republic of Congo, but for the fact that the code, the law of Congo did not make express mention of checks as being capable of debts arising from unpaid checks as being capable of recovery under the injonction de payer procedure. Now, but what about Cameroon? Cameroon, of course, is a republic. It is a republic. Politically, it is one country, but when it comes from the legal perspective, we have two different countries here, and the Constitution guarantees equal status to the two legal districts, the two legal divides in this country, and that is why it is important, and that is why we decided that we have to look at the procedure, the judgment on the undefended list procedure as well here to make a comparison, because that is what was obtained, or that is what was applicable in this part of the country. Of course, we shall realize that the two procedures are similar, even though they may have some differences in some respects. That is what the OHADA legislator took into consideration in the elaboration of the Uniform Act. But of course, we take into consideration the specificities of the different countries, the member states, and I must say that they are 17 in number. In the elaboration of the Uniform Act, some roles were devolved to national authorities and of course to regional authorities. And that was because the intention of the OHADA legislator was to take into consideration the peculiarities, the specificities of the different the practices of the different countries, and to have them integrated or incorporated in the Uniform Act, so that it could be one that was acceptable to all. So now, but which were these regional authorities we are talking about? There are about 3 in number. There was the Permanent Secretariat, which prepares draft Uniform Acts, which it sends to the government. And of course, the government had to resubmit those drafts with their comments to the Permanent Secretariat within a specific period of time. After that, the Permanent Secretariat would have to submit the draft and the comments of the governments to the Common Court of Justice and Arbitration, the CCJA, for its opinion. And of course, that opinion had to be given within a specified period of time. After the opinion is given, then the draft, of course, the Permanent Secretariat would incorporate the observations made and will produce the final version of the Uniform Act, which it will table to the Council of Ministers in their next meeting. And the role of the Council of Ministers, again, a regional body, was to examine, deliberate upon, and adopt the Uniform Act. And that was the procedure, which procedure is aligned in the OHADA Treaty itself, and of course, Articles 1 and Articles 1 and 5 to 12. But then, like we did say, there were differences. The different countries had their own peculiarities, their specificities, and this had to be taken into consideration. And that is why the OHADA Treaty devolves certain roles to national authorities, that is the governments as individual governments of the member state, because they had to make proposals. Once the drafts were submitted to the member states, they were called upon to make their recommendations, their comments, their proposals, which had to be taken into consideration by the permanent secretariat. But that having been said, of course, what were the contents of the injonction de paix? Because, of course, the Uniform Act introduced the injonction de paix, and we may ask, what were the contents of the injonction de paix, and in what respects were they similar, if at all, to the undefended list procedure? Of course, the injonction de paix is a form of summary proceedings contained in the Uniform Act, and it provides a simple and inexpensive mode of recovering debts. It is available to creditors who do not have a writ of execution, enabling them to recover claims against third parties. And of course, the procedure was available by reason of Article 1 to claim if one had to avail himself of that procedure, then the claim must be certain, of a fixed amount and due. The debt may arise, of course, the nature of the debt may arise from a contract or result from the issuance or acceptance of any negotiable instrument or a check without cover or insufficient funds. And of course, the application had to be made to the court with competent jurisdictions. But of course, competent jurisdiction of the place of domicile of the debtor, or any one of them where there were several debtors. But the parties, the Uniform Act equally allows the parties, of course, provides that the parties may derogate from the rules of jurisdiction by electing a domicile in their contract if the debt arises from a contract. And of course, the Uniform Act, of course, provides that the request must be made to the registry of the court, and we can see the rest on the slide. So what we may say about the procedure is that the procedures are essentially derived from French law, but differ slightly in some respects. And of course, we see this under the Senegalese law. Of course, we shall find that the Senegalese law equally provides for the method of seizing the courts. And in respect of the injonction de paix, the procedure was initiated before the regional courts, that is following the Senegalese code. Of course, the application was deposited at the registry and so on and so forth. And the same was the case under the code or the law, the Republic of Congo. It does provide how the court may be seized. And of course, here it is said that the petition could be oral or it could be in writing. And if it is oral, then of course the registrar of the court, assisted if need be by an interpreter, would have to do the application in writing and the rest. So the injonction de paix procedure was made to the president, and that is under Congolese law, was made to the president and not to the registry, as was the case under Senegalese law. And of course, this has not, the precision has not been given under the Ouahada Uniform Act. But under the Act, of course, the request is made, will not be admissible unless it contains, one, the full names. Of course, it stated that the full names, profession, domicile of the parties, for legal entities, their form, name, and registered office, and the specific amount of the claim with different elements of the claim and the basis of the claim, the originals of certified copies of the supporting documents must equally be included. And where the request is made by a person not domiciled in the state of the competent court, it must contain, under the penalty of being declared inadmissible, election of domicile within the jurisdiction of the court. The procedure, the grant of the injonction de paix under the Uniform Act, the procedure is governed by Articles 5 to 8 of the Uniform Act, and the procedure equally includes an application, making an application introducing certain documents, the application should be addressed to the president of the court, and after examination, it may be rejected in whole or in part, depending on the appreciation of the court when it examines the application. But we have to understand that under both the Senegalese and Congolese courts, of course, the rejection could not be the subject of appeal unless the applicant resorts to the common or ordinary law provisions of their respective countries. While under the Uniform Act, the petition and the injonction de paix decision are kept, and under the Uniform Act, these are kept by the clerk of the court. A copy is issued to the applicant. The original of the documents submitted in support of the application are returned to the applicant, and the certified copies are kept at the registry. Where the request is rejected, the application and the documents are returned to the applicant. Of course, where it is granted, the creditor shall cause a copy certifying the request and the injonction de paix decision to be served to each debtor by an extrajudicial act, and the decision shall not be enforceable if it is not served within a given period of time, 3 months from the date it was issued. And of course, notification of the decision must contain certain elements which are there contained on the slide. And the notification, of course, shall also state the time which the opposition, that is notification, that the debtor intends to oppose the grant of to oppose the decision ordering payment. And of course, such notification must be made within a given period of time, and must contain the number of elements which have been specified by the OHADA legislator in the Uniform Act. And of course, the Uniform Act equally tells us or gives if someone were to oppose the decision or appeal the decision of the injonction de paix, the conditions are stated clearly in Articles 9 to 15. And that must be done within a specific time. And of course, the opposing party equally is required to notify his appeal to all the parties and to the registry of the court that issued the order, and the rest, we have them there on our slide. But then the opposition may fail. And if it fails, what will be the attitude of the court? The court, if it fails, the court shall immediately rule on the application for recovery, even in the absence of the debtor, and the decision shall have the effect of an adversarial decision. And of course, the burden here, the burden of proof is on the creditor to establish the existence of the debt and the decision of the court on the injunction, on the opposition shall overrule the injunction to pay decision. But where the court gives judgment on the opposition, such judgment can be appealed against within a period of 30 days from the date it was delivered, and the appeal is done in accordance with the legislation of the member states. These will pass. Now, let us make a statement or comment on the time of appeal. What do we realize? The Uniform Act is precise on the time limit for appeal, 15 days, with possibility of extension for the injonction de paix decision, and 30 days for appeal against the decision on opposition to the injonction de paix decision. The Uniform Act, however, leaves the procedure for appeal to the legislation of the member states. And the period for appeal in civil and commercial matters in the legislation of the member states are 3, 2, and 1 month respectively. But what we have to understand is that notwithstanding that, neither the parties nor the courts can circumvent the mandatory provisions of the Uniform Act by extending the time for appeal beyond 30 days, as that would amount to undermining the very purpose of the injonction de payer as a simplified recovery procedure under the Uniform Act. And of course, the effects of, what then are the effects of the injonction de payer, where there is no opposition within the time frame? Of course, the creditor may request for the affixing of the executory formula on the decision, in which case it shall have the effect of an adversarial decision and shall not be subject to appeal. And of course, the request may be oral or in writing, and it is made to the registry of the court and must be done within a certain time. The register of the register is kept at the registry for this purpose, which is initialed and numbered by the president or the court. But the question then is, how does the injonction de payer procedure, how does it differ from the undefended list procedure in their application? Article 10 of the OHADA Treaty states that the OHADA Uniform Acts are directly applicable and are binding on the member states, notwithstanding any conflicting provision of national law, be it previous or subsequent. However, use of the injonction de payer procedure is sometimes possible only when resort is made to domestic instruments which do not conflict with the Uniform Act, as for example, where the community legislator leaves certain issues to be governed by the national laws of the member states. In the common law jurisdictions of Cameroon, a summary trial, like we said earlier, the undefended list, which of course was as a result of the High Court Civil Procedure Rules of the states of the Federation of Nigeria, were applicable as far as simplified recovery procedure is concerned. And the undefended list procedure has then some common characteristics, some common traits with the injonction de payer procedure. And this requires that, therefore, an in-depth analysis of the procedure. What is the nature of the debts to be recovered? We realize that the debt, the nature of the debts to be, well, both procedures are available for simplified recovery of debts under well-defined conditions. And this was so under Senegalese law, this was so under Congolese law, and of course was equally so for the other African countries that were under the colonial administration of France. But what we have to comment about all of this is that the amounts capable of recovery differed. They were either unlimited for other countries that were under French colonial administration, or limited to 1 million francs under Senegalese law, or to 250,000 francs under Congolese law, respectively. And in the majority of the countries, debts for which recovery was sought could arise from the acceptance of checks without cover. This is not specifically mentioned under Congolese law. So, the provisions of the Uniform Act on the injonction de payer, it was equally available for such debts, only this time in a harmonized form, because it has taken into consideration all what we said before. It is also, the procedure is also used to recover a liquidated claim, which is certain and due for immediate payment. So the specificities of the Uniform Act on the injonction de payer is that the OHADA legislator gives a broader and harmonized scope to the nature of debts capable of recovery through the injonction de payer procedure. First, the amount of the claim is not limited as it was under Senegalese law, and it suffices that it is a claim, it is a sale liquidated claim which is certain and due for payment arising in any one of the ways stated earlier. And of course, second, the OHADA legislator includes expressly in the provisions debts arising from the acceptance of checks without cover or insufficient cover, which was unavailable, at least expressly, under Congolese law. Therefore, there is therefore harmonization of the nature of the debts for which the procedure is available under the Uniform Act. And of course, the undefended list. The undefended list here, we decided to limit ourselves to Order 23 of the Kwara State and Oyo State High Court Civil Procedure Rules, because Southern Cameroon was joined especially to the Eastern Nigerian states, and for which unique laws were passed. But of course, application they had to start by writ of summons, while on the Uniform Act, it will be by application or a request, and it was equally for a debt, a liquidated money demand, and other claims. So the similarity with the injonction de paix is that the debt must be for a debt or a liquidated sum, which the community legislator refers to in Article 1 of the Uniform Act as a claim that is certain of a fixed amount and due. The undefended list procedure is also available for any other claim. This is wide enough to include debts arising from the acceptance of checks without cover or insufficient cover. And under both procedures, the applicant is not required to have a title, that is a court judgment, on which to base the claim. Now, the cost. The cost, under the injonction de paix procedure, it is a party who initiates action, the cost, and of course, proof of claim, and the same is true under the undefended list procedure. And the application should contain the specific amount of the claim, and with the elements of the claim, the basis of the claim, etc. And where, in the light of the documents submitted, the request appears to be reasonably founded in whole or in part, the president of the court will issue the order for payment for the amount that he will set. And this is equally the case under the undefended list procedure. But then what comments can we make on that? Proof of the claim is less complicated and less costly under the Uniform Act than it was under the undefended list procedure. And what about commencement of hearing procedures under both procedures? The injonction de paix was by application, we have said, and we don't have to come back to that. And of course, it was made within a given time frame. And of course, it could be challenged. And if after the challenge, a decision is taken, there could be an appeal, but not by way of rehearing, but of course to a superior court. And this had to be made within a specific time period. And of course, realize that appeals are governed by different pieces of legislation, especially given that the OHADA legislator gives back this possibility of appeal to the legislation of the different member states. And like we said earlier, appeal could be made in civil and commercial matters under the legislation of the different countries within a given time period. 3 months, 2 months, or 1 month, but under the OHADA Uniform Act, it is 15 days for opposition or 30 days for appeal of the decision after opposition, and known, even if the appeal is made before the national courts and under national legislation, they could not circumvent this period of appeal provided by the Uniform Act. And of course, the same was equally the case with the undefended list procedure, because it starts by way of application, but proof was by way of affidavit, and of course, which must be attached to the application for a writ of summons. And of course, that was somehow more complicated than we have under the Uniform Act, because it entailed extra costs and time to be borne by the plaintiff who seeks to avail himself of the undefended list procedure. And of course, if the court was satisfied of the grounds upon which the application is brought, it could enter the suit for hearing under the undefended list and would mark the writ of summons as undefended, failing which, of course, there could equally be, that is where there was no opposition. But one thing we have to draw our attention to is that under the undefended list, the opposition was made even before the decision, the mandatory order was given, unlike under the Uniform Act, where the opposition can only be made after the mandatory order has been issued by the court. That is something that we should equally take note of. So like we said, the opposition or notification is made before the issue of the mandatory order, and it must be done within 5 clear days under the undefended list procedure. And that was not the case under the injonction de pays procedure, where opposition is only possible after the decision has been made. And to avoid differences in the practice in the member state, the other legislator makes certain precisions. Instead of an affidavit under the undefended list, the applicant is required, under the penalty of inadmissibility or the application being declared inadmissible, to introduce the full name, profession, and the rest, and of course, a specific amount of the claim with the different elements of the claim are their basis, and the applicant is equally required to include originals of certified copies of the supporting documents, and this is less expensive to procure and to administer than it was the case under the undefended list procedure. And of course, once the court delivers judgment, appeal could, or under the undefended list procedure, once the court delivers judgment, appeal could not be by way of rehearing in the same court, but would be made to a superior court, that is the Court of Appeal. Under the Uniform Act, the decision of the court on the opposition may be the subject of further appeal, but the Court of Appeal, before the Court of Appeal of the member states. And of course, what were the effects of the decision, the injonction de pays decision, and the judgment on the undefended list? The effects were the same. The judgment, once it had received, when the judgment has received the executory formula, it becomes binding, and of course, it becomes enforceable everywhere. But then, the difference here is the fact that under the undefended list procedure, the decision has the effects of one reached after hearing both parties, yes, and of course, the difference being that under the undefended list procedure, as it was before the Uniform Act, the decision was only enforceable in one territory, and that was Cameroon, except of course, there was a bilateral agreement, enforcement agreement. It could not be enforced out of Cameroon. But once the decision under the injonction de pays in the Uniform Act receives or is affixed, once the executory formula is affixed on it, it becomes binding or in the 17 member states. And that is a difference, one of the differences between the undefended list and the procedure and the injonction de pays procedure. So it is less complicated. Once the executive formula is affixed on the decision, the injonction de pays decision, it is enforceable in the 17 member states. And under the undefended list procedure, enforcement of the judgment out of the country whose court delivered it may require special bilateral agreement to that effect between the countries. But then there were some differences between the injonction de pays procedure and the undefended list procedure. And this has to do with jurisdiction to hear simplified debt recovery procedure. Under the undefended list procedure, the jurisdiction, the courts with competent jurisdiction were precise. It was the High Court. Under the injonction de paix under the Uniform Act, the court is not precise. They say, the legislator says, the court with competent jurisdiction. And which court has competent jurisdiction is referred to the legislation of the member states. And there may be differences there because under some legislation, the precision is not given. While in Cameroon, the Judicial Organization Ordinance of 2006 as amended and completed in 2011 is precise. If the matter is less than 10 million, it falls within the jurisdiction of the Court of First Instance. If it is above 10 million, it falls within the jurisdiction of the High Court. That precision, it is not very, very clear under the legislation of some other countries. And so the question may be read, the question may be asked, what then if there is this conflict and if the matter, especially given that the Uniform Act does not give the maximum amount, it merely says that the injonction de paix procedure is available for debt or claims, but not the amount, then how would that matter be treated in the other countries if appeal is made and it becomes a bit complicated? And again, there may be derogation, we said earlier. Of course, derogation is equally treated under the Senegalese code and equally under the Code de Procédure Civile et Commerciale, which is applicable in the majority of the states and French-speaking Cameroon. But then we read through the Senegalese and even Congolese law, we shall see what they have provided as far as derogation is concerned. But we may say it is not clear. Under Cameroonian law, of course, I have made mention of that. And of course, what about jurisdiction to hear actions on the undefended list? I've said the court is clear. It is the High Court, and there is no confusion there, as we may have under the Uniform Act. Another issue which we should mention here on the both procedures is that the Uniform Act, in the Uniform Act, the legislator emphasizing on conciliation of the parties when the debtor opposes the injonction de paix decision, and it requires that an independent, of course, conciliation will require the intervention of a third party to help the parties to settle the matter. This was, of course, mentioned, it was a provision mentioned in the laws of the majority of the countries, or in the laws of the majority of the countries, including Senegalese and Congolese law. But then the difference was with the common law jurisdictions, where conciliation as such was not recognized. Of course, until recently, conciliation was not recognized except for divorce proceedings. And so the undefended list procedure, conciliation, has not been expressly provided for except for Order 23, Rule 5, which states that nothing herein shall preclude the court from hearing or requiring oral evidence should it so think fit at any stage of the proceedings under Rule 4. And this provision, we may say, allows the court the discretion to decide each case on its particular merits, but there could equally, the opportunity could equally be seized to introduce arbitration as one of the methods of settling, but it is not expressly stated in the undefended list procedure, the legislation on defended list procedure. And enforcement of judgment, we had made a statement on that. Under the undefended list procedure, it was just in one territory. but under the Uniform Act, it involves the 17 member states. So the Uniform Act therefore ensures uniformity of rules on simplified recovery procedure across national borders and reduces costs related to the execution and enforcement of judgment. So what do we say by way of conclusion is that notwithstanding the claim that the injonction de pays procedure is of civil law origin because it is inspired from French legislation, it is similar in many respects to the common law undefended list procedure that was practiced in the common law jurisdictions of Cameroon. The elaboration of the Uniform Act on simplified recovery procedures and measures of execution or measures of enforcement of judgment was done to avoid or minimize the discrepancies that hitherto characterized inter alia simplified debt recovery procedures in the legislation of the member states. Hence, the inclusion of the injonction de pays procedure in the Uniform Act by the community legislator. Before the Uniform Act, rules on the procedure were found in several instruments applicable in limited geographical areas. This included the undefended list procedure, which was applicable before the courts in Anglophone Cameroon, a common law jurisdiction. This disparate and multiple nature of the instruments and the practices did not guarantee legal and judicial security to investors and was inimical to foreign direct investment and trade in the countries. Today, the OHADA member states have uniform rules and procedures in one instrument for simplified debt recovery procedures. To guarantee its effectiveness, though, initiation of the procedure and physical enforcement of judgments are returned to the national government, but now in a simplified process with the source of the law being easier to identify than it used to be the case in the member states. This includes judgments on the undefended list procedure, which the Uniform Act has abrogated or has replaced. Thank you. I just had to make a summary of my presentation because of the time. 30 minutes, if I had to read through what I had prepared, it would have taken more than an hour. So I just tried to make a summary of what we have here. And thank you for your keen attention.
Thank you, Burkhard. I was thanking Professor Dashako for his too rich presentation, summary, he said, which shows in which way the uniform acts of the OHADA are the result of the technical compromise between different legal sources, mainly French and English law, but not only. OHADA, I think, is a good and interesting laboratory of regional law and justice, gathering 17 state members with 4 working languages, different legal culture. Well, it's time now to open the discussion for 20 minutes. We would like to ask a question or make a comment. For that, please, I remind you that you must click on the raise hand button appearing at the bottom of the display or write a brief note in the chat. Rick Marcus and Margaret put interesting comments on the chat. I invite you to read them. Maybe Rick or Margaret, you want to summarize your comment?
Loic, can you hear me?
Yeah.
Okay, well, really 2 things. One is what we would call realist approach to the very thoughtful presentation we just had compared to our US setup. Actually, in US state courts, according to a study done in 2020, what really happens with a very large proportion of the cases is exactly the same. We have unrepresented debtors and often banks and credit card companies that are seeking to enforce debts. and they just immediately get default judgments which end up being entered against the debtors. And that's not supposed to be the same, but it is in operation the same. That's point one. Point two is an advertisement. I'm holding up here a book that was just published as a product of Massa De Lucci's conference in late 2019 called Effective Enforcement of Creditors' Rights, which is a supplement, I think, with regard to many countries in Europe and Asia and some in Latino America. Several of us were here. Burkhardt was there. Eduardo Orteza was at this conference. So to take nothing from today's presentation, it seems to me we can expand our view across borders again, using studies like this one. And Margaret and I have been exchanging things in the chat also about how our actual operations in court compare to the arrangements in Africa that we just heard described. So thank you. Those are just my advertisements for today.
Thank you. Thank you, Rick. Margaret, do you want to add something?
Sure. I mean, I guess I just have two questions. One very practical, and the other is more a comparative, a comment on comparative, adaptations. And the first one is just, at least in the US, we do try to protect the debtor by requiring the creditor to post some kind of security in the event that the application was incorrect. Because when you tie up assets, it still could create damages and it would cost the debtor expense in trying to come back in and defend it. And so I was just wondering if in Cameroon and Senegal, there's that provision. And then the more comparative question is really, it's interesting that the differences between countries is really on the nature of the claim and on the amount. And I was just trying to figure out whether that difference is due to the different economic conditions of the countries. And if it were, then actually it probably should be based on the different economic conditions of the debtor as opposed to the creditor in terms of this kind of injunctive application. So those are my two questions.
Thank you, Margaret. Professor Dashako, I give you the floor.
Okay, thank you very much. As far as the first question is concerned, whether they were required, if a creditor were to initiate the action, whether there is any requirement that they should deposit something as security, if I got the question right, whether there should be something they deposit. Well, the Uniform Act does not state anything of that nature. But what it does, even though it is a uniform act that covers the 17 member states, it merely outlines the procedure, but now action has to be taken before the national courts. And if action has to be taken before the national courts, whether there should be something or they should deposit a caution, in case the action fails, will be determined by the laws of the different courts and not by the Uniform Act itself. That is why we did say that the Uniform Act, we have issues that have been defined, been determined by the Uniform Act. But the problem with the Uniform Act is that it does not determine, it does not define the procedure for the commencement of action. And that is left to the laws, the national legislation to be governed. So it will now depend on each member state. What do their laws provide? If an action has to be commenced, if an action on the injunction to pay has to be commenced by a creditor, will that creditor be required to deposit something as a caution? But then Generally, what we have seen in some legislation is that a difference is made between a procedure commenced by a national and a procedure commenced by someone, a citizen of another country. But then that is a national issue. That is determined by the court, by the legislation, the national legislation of the different member states. And so it has not been regulated by the OHADA Uniform Act. That is what I have to say. The second question, I don't know whether it was a question or an observation, but can you refresh my memory on that?
Oh, no, I was just, it was more probably an observation that the differences between the country that you've highlighted about this procedure is more based on the types of claims that could be brought in and the amount. And I'm just wondering if it's really a reflection of the economic development of each country.
Well, I get the question now, but the Uniform Act does not provide a limit. It does not provide a limit. So for any claim, an action can be brought, or the injunction de paix procedure can be used by the creditor. And because the Uniform Act does not provide a limit, then that limit will be determined by the national laws and not by the Uniform Act. And that is why I say, if we look at the Senegalese code, under the relevant provision, it was stated that the procedure can only be initiated for the recovery of debts which were not above 1 million francs, CFA 1 million francs. Under the Republic of Congo, it is stated that it could not be initiated for debts which were more than 250,000 francs. But because the Uniform Act has come in now and has not placed a limit, so of course, automatically the provisions of the Uniform Act would abrogate those provisions of the Senegalese Code and the Republic of Congo Code. But unfortunately, if we read through their present legislation, nothing, or it is almost silent as to the amount. So the question, and that is what I did ask. Unfortunately, I could not go further because of time constraint. Now, what if the amount is more than 1 million francs, which is the court, which is the competent court, let's say under Senegalese law, for example. So it is not stated. But what is interesting under Senegalese law is that it is stated that where the amount is more than 1 million francs, then the notification or service of the decision of the court must be done by a bailiff. But which is the competent court? We do not know. So I don't know whether it's based on it is based on the reflection or what the national legislators think. So I don't think it has anything to do with the economy because they have not been influenced by the community legislator.
Thank you. Thank you. More comments? More questions? Wow.
Burkhard has one. Let's see.
Burkhard.
And Belig.
Burkhard, I don't see you, Burkhard. Oh, sorry.
Okay.
Okay, Burkhard.
Thank you, Loic, and thank you, John, for this very interesting presentation. And I would like to ask you whether you have some information about the application of this procedure in the different OHADA states. Are there states where it is more applied than in others? If there are some, do you have an explanation? It's maybe not an easy question to be answered immediately. And my second question is, in Europe, at least, we have these procedures more and more often based on forms. Are forms being used in the African states just to facilitate the handling of the proceedings. And it might also be interesting to learn a little bit whether computer and electronic exchanges are available. Thank you.
Next question. Can you remind me, let's go one after the other so that I may not lose. So the first question was,
was the application of the procedures in the different countries of OHADA. Do you have some statistical information, whether there are similarities or differences?
I get the question. But like you said yourself, it's a difficult question to answer. Statistics, I don't think so. But what is true about uniform laws or community laws is that we have states which are more interested in those community laws than others. It will, maybe I'll be getting into politics, which is not my role here. If I were to say this country, some countries are more devoted or are more inclined to respecting or applying the Uniform Act than others. But what is true is that some countries are more. I don't know why, because I can't explain that. Because we find that in some countries, in the OHADA sub-region, they continue to apply their national laws as if the OHADA Uniform Acts or the OHADA laws do not exist. And since the Common Court of Justice and Arbitration may only have the opportunity to rule on that if there is an appeal, and these appeals never get there, then we don't know what the OHADA or the institutions put in place by OHADA would say about this. But what we know is that in 2001, the advisory decision of the OHADA Court of Justice, that is the Common Court of Justice and Arbitration, was that the OHADA Uniform Acts, they abrogate all national legislation which were contrary to the provisions of the OHADA Uniform Act. But now, to what extent is that respected is another story. But I know, I can say, some countries respect more and they apply more the OHADA Uniform Act than others, but I will not venture to give names of countries because I don't have statistics on that.
Thank you very much.
Yeah. And now the second, if I may, refresh my memory.
Was about the use of form and information technology in these procedures.
Well, OHADA, we should understand, it is a uniform, it is a harmonized law, but OHADA would rely on what? On the decisions of national courts. And when there is an appeal to maybe the CCJA, the Common Court of Justice, and that is when there will be a uniform procedure. So now the use of forms and all whatnot will be determined by the national legislation of each, the legislation of each member state. That has not been provided for by the OHADA, the community legislator. So it will depend on where. So if it is in Cameroon, and you have to institute an action, and it is stated that it may be forms, then you have to do that. And of course, when the use of computers would equally require that, maybe not as far as the commencement of action is concerned, but maybe in the recording of decisions, the reporting of decisions, maybe it can be computerized to facilitate dissemination, but that is the extent to which we'll go for the time being. And maybe that is a reflection. The OHADA, the community legislator, should reflect on that, on how to introduce maybe forms to create a uniform, because they want just referring the matter to the national legislature is not enough. Maybe they should do more than that. Now that if it is, yes, but this is the form it should take, but the many state that the application must be done to the president of the court or this. I think the introduction of forms would facilitate and would help further the process of harmonization.
Thank you very much.
Okay, thank you. Billy Gilbati has raised hand, and then Professor Chase also wants to react. Billy, I give you the floor.
Yeah, thank you very much. Thank you very much for this very informative and interesting presentation. I'm Billy Gilbati from Osaka University, and I'm very happy to be here with you all. The OHADA law system is really puzzling for me, though interesting, because it harmonized substantive law, and now we see some aspect of harmonization or unification. But when it comes to circulation of judgment, it seems to me that the law is not harmonized. So, and I was very much interested to hear and to learn about this law because it introduced a kind of cross-border circulation of order for payment. Now, my question is that you mentioned that this order is enforceable everywhere in the 17 countries. So I would like to know whether this enforcement is direct in the sense that the holder of this order does not need to go through enforcement procedure, and what would be the defenses for the defendant to oppose the enforcement of such order? You can think about, even in Europe, for example, they have a unified system, but there are some defenses for the defendant. For example, there is a prior judgment, or the defendant has already paid the amount ordered by the court. Are there defenses that the defendant can invoke in order to oppose or to challenge the enforcement of those injunctions? And thank you.
Professor Dashako.
Okay, thank you for that question, which is very, very interesting. The possibility of opposing a decision, in fact, under the Uniform Act, there are two stages. There are two stages, and I think it should be done at that level. Once the decision, or once the order is made by the judge or by the court, the defendant, in this case the debtor, has the possibility to oppose, to challenge the decision. And that must be done within a specified period of time. He can challenge that decision, and this is the time he has to do so. So we have two stages. If he challenges the decision, and of course the court believes or holds that no, the challenge is one which is not admissible, and goes further to deliver judgment on that procedure, the defendant again can appeal against that judgment before the higher courts, in this case, the Court of Appeal. So if the defendant has to challenge that, he has enough time, either by way of opposition or by way of appeal. And if it is, and he may, if he does not, then begin another procedure altogether, which will now be in accordance with the judgment or in accordance with the legislation of the member states. So if that has been done, but if it does not do that, and of course, the judgment becomes a judgment which is enforceable, res judicata, in the sense that it has received the executory formula, and of course it has to be enforced in other member states. If the defendant is not satisfied, then what the defendant will do, and the Uniform Act gives the defendant the possibility to do that, it will be to institute an action, but now not based on the OHADA Uniform Act, on the common law provisions, the ordinary law provisions of the said of the country concerned or where enforcement is sought. But failing which, once the executory formula is attached, is affixed on the decision, then it is in principle enforceable within the 17 member states.
Thank you very much.
I don't know whether I've made myself clear.
Thank you.
Yeah, it's clear. Yeah, thank you.
Okay.
Thank you. I turn now to Professor Chase. Oscar, do you want to put a question or a comment?
Yes, thank you. Can you hear me?
Yeah.
Okay, good. First of all, I want to say that it was quite important, and I learned a great deal more of the African procedures, and I thank our Depasho today. Thank you so much. I do want to talk something a little bit different from what others have said. Is one of the problems that we have in the United States, I would say, and any other courts around the world, has been the problem of time, and this goes back, in fact, to Rome, where there are always claims it's too long, it takes too long, et cetera, et cetera. And certainly in my own New York courts, we have these problems. And it struck me that some of the short days that have been used, at least in said, in the courts that we have talked about through the OHADA and so forth, as such as there are some that 5 days, 15 days about various things. I won't go through the details, but I thought that was quite interesting. I just wonder to what degree these short amounts of time actually work. And if they do work, please tell us how you get it, because we'll learn something. Thank you so much.
Thank you, Oscar. John.
Yeah, thank you once more. I would like to come back to one thing. The 5 days had to do with the undefended list procedure. But once the application was made, the defendant had, if he did intend to defend the action, 5 clear days within which to submit to the court a notification of intention to defend. That was the procedure under the undefended lists, which was applicable in the common law jurisdictions. But I must say that the Uniform Act has replaced that, because it has now taken over. That is, it is a Uniform Act that is applicable even in the common law jurisdictions of Cameroon today, except where the Uniform Act allows certain issues to be decided by or to be governed by national legislation. And that being the case, if it comes to Cameroon, for example, which is a bi-jural state, now it will depend on whether or not the action was in, or the action emanated from the French-speaking regions of Cameroon or from the English-speaking regions of Cameroon. Because like I said earlier, it is one country politically, but 2 countries as far as the law is concerned. Now the procedure under Uniform Act, we have 2. Whether it is opposition, and the opposition, because once the decision is given, the court gives a decision, that is the order to pay, then the defendant, that is the debtor, has a period of 15 days within which to defend or to oppose, to challenge the decision of the court. But the challenge or the opposition may be rejected by the court, may be declared inadmissible by the court, in which case he can now make an appeal, and the appeal will be made to a superior court, the Court of Appeal, and he has 30 days within which to do so. And that's why I mentioned earlier during my presentation that yes, the matter has been referred to the legislation of the member states. And if we were to look at the legislation of the member states in terms of appeal, we have three situations here. The majority of these countries, appeal was governed by one law. In Senegal, another. In the Republic of Congo, another. And the time for appeal, we had 3 months in civil and commercial matters. In Cameroon, for example, and not just Cameroon, all those countries, those former French, those countries that were held by France, which apply the Code Civil, the appeal period was 3 months. In Senegal, the court provided that the appeal in civil and commercial matters should be done within a period of 2 months. In the Republic of Congo, it is stated that it should be 1 month. But what has the OHADA legislator done? Because it is a simplified debt recovery procedure, it is fast, has reduced that period of appeal to 15 days if it is an opposition, and 30 days if it is an appeal on the decision, an appeal of the decision on the opposition. So what is that supposed to mean? That if it is a simplified recovery procedure, the injonction de payer, if the appeal is based on that, you are appealing against the decision on the injunction, the mandatory injunction to pay, it must be done within 30 days as from the date the decision was issued, and not under the period for appeal in the national legislation, which is 3 months, 2 months, or 1 month. So if it is in Cameroon, for example, or any of those countries applying this French code, then notwithstanding the fact that there is a longer period for appeal, they must respect the provisions stipulated in the Uniform Act. The appeal must be done within 30 days if it is an appeal to the Court of Appeal, and not 3 months or 2 months, because that is a mandatory provision. That is a mandatory provision which cannot be circumvented, because what they do, they implicitly repeal or abrogate the provisions of national legislation on that particular point, the period during which appeal should be made. I don't know whether.
Yeah, yes, thank you. And as in other areas of the world, there are ways to move better than the shorter. On the other hand, you seem to have very clear claims on the limits of the times. And I certainly learned something. So thank you so much.
Thank you. Thank you, Oscar. Well, we have to come to the end of the discussion. Thank you all for your questions and comments. Thank you again, John, for your presentation and your complementary answers. I think it was a fruitful discussion. It's now time to break, but because we are late, we will only have a 10-minute break. So we will start again at 4:40. Thank you. We can, and I now let English for French. Nous entrons donc maintenant dans la deuxième partie du webinaire, en remontant vers le nord de l'Afrique avec l'exposé du professeur Sami Bostanji, exposé intitulé « Droit judiciaire privé comparé, regard général sur les droits des pays arabes ». La durée de cette séquence sera de 45 minutes en raison de la traduction consécutive opérée par M. Huillet, qui est avec nous, oui, je le vois, et auquel je donne immédiatement la parole.
Bonjour, merci. Enfin, c'est plutôt au professeur Bostanji.
Non, parce que si vous voulez bien traduire ce que je viens de dire.
Ah, pardon. We are now going to listen to Professor Bostanji's intervention on compared private judicial law, and I will be translating it from from French into English. Sorry.
Thank you. Sami Bostanji est un spécialiste réputé de droit international privé. Il est docteur en droit de l'université de Dijon, si je me souviens bien, oui. et il enseigne à l'université de Tunis El Manar, où il dirige le laboratoire de droit des relations internationales, des marchés et des négociations, le DRIMAN, après avoir été doyen de la faculté de droit et des sciences politiques.
Professor Bostanji has a PhD from the University of Dijon, and he's a professor at the Faculty of Law and Political Science in Tunisia. And he works in a laboratory for research. Mais j'ai pas réussi à Riemann, ok.
Alors, comme pour le professeur Dachako, je lui suis reconnaissant d'avoir accepté de décentrer un peu son regard en le dirigeant vers le droit judiciaire privé, qui n'est pas strictement au cœur de ses intérêts académiques. Je suis heureux de lui donner la parole en veillant à ce que sa présentation et la traduction de M. Huillet restent dans la limite de 45 minutes.
And so Professor Bostanji is going to have the floor now, and we will make sure that this presentation doesn't exceed 45 minutes.
Merci, Monsieur Cadier. Bonsoir tout le monde. Je tiens d'abord à vous exprimer tout le plaisir d'être aujourd'hui parmi vous en vue d'animer cette seconde partie de ce webinaire. Cela n'aurait pas été possible sans l'aimable invitation qui m'a été adressée par le professeur Loïc Cadier. Qu'il en soit vivement remercié.
Good evening, and thank you for having me animating this second part, which I thank Mr. Cadier for.
Mes remerciements vont également à toute l'équipe organisatrice du Max Planck Luxembourg pour tous les soins apportés à la mise en place de cette manifestation scientifique.
Thank you also to all the team at Max Planck Institute Luxembourg for their help in setting this presentation up.
Et je tiens à remercier d'avance M. Huillet pour l'effort qu'il entreprendra en vue de la traduction de mon exposé.
And thank you to Dr. Huillet for his efforts in translating the presentation.
L'exposé en détail des 22 systèmes procéduraux des pays rattachés à la Ligue des États arabes relève certainement d'un travail encyclopédique qui dépasse très largement le cadre de ce webinaire.
Giving a detailed presentation of the 22 procedural systems of the Arab states definitely is an encyclopedic task far bigger than this webinar.
Compte tenu du temps qui m'est imparti, je me contenterai de jeter un regard général sur ces systèmes, un regard qui fait l'économie des détails au profit des grandes tendances qui caractérisent l'organisation judiciaire et les éléments de la procédure.
Due to the time limit, I shall present an insight of these systems, an insight skipping details, focusing the major trends, characterizing the judicial organization and elements of procedure.
Ce regard portera sur le mouvement des idées en la matière dans les pays arabes, les principales déclinaisons de ce mouvement, les facteurs d'influence et les singularités qui marquent certains ordres juridictionnels étatiques.
This view concerns the movement of ideas within private judicial law in Arab states, the main reasons for this movement, factors of influence and the singularities marking some state jurisdictional orders.
Dans ce contexte, le droit musulman constitue l'arrière-plan historique commun à l'ensemble des systèmes juridiques de ces États.
In such a context, Muslim law is a historical background common to all the legal systems of those states.
En terre d'islam, l'organisation de la justice s'articule autour d'un personnage central qui est le qadi, terme arabe désignant le juge.
In Islam, the organization of justice revolves around a pivotal character, the qadi, which is Arabic for judge.
Le qadi a succédé au hakam, l'arbitre de la période pré-islamique.
The qadi took over the hakam, who was an arbitrator in pre-Islamic times.
En l'absence d'un État central, le hakam était appelé à trancher les litiges qui s'élevaient entre les particuliers, voire même entre les tribus, en faisant application des coutumes locales.
With no central state, the hakam had to settle disputes between private individuals or even between tribes, therefore applying local customs.
Comme dans de nombreuses civilisations antiques, la justice privée a précédé ici la justice étatique.
As in many ancient civilizations, private justice came before state justice.
L'extension des territoires musulmans suite aux conquêtes, la prolifération de la population musulmane suite aux conversions et surtout l'émergence d'un État central appelé à assurer l'ordre au sein d'un vaste territoire sont autant de facteurs qui ont amené à instaurer une justice publique.
The expansion of Muslim territories, the proliferation of Muslim populations, and the emergence of a central state supposed to ensure social peace and order over a huge territory, in particular, contributed to set public justice, whose organization became more precise with time and spatial evolution of the Muslim empire.
La singularité de la justice en terre d'islam ne peut être saisie sans égard au caractère religieux qui la coiffe.
The singularity of justice in Islam cannot be grasped without consideration for the religious aspect of it.
Ce caractère religieux de la judicature en terre d'islam touche à la fois la personne du qadi, la fonction de juger et les sanctions affectant les défaillances du qadi.
This religious aspect of the judicature in Islam affects both the person of the qadi, the functions of judging, and the sanctions affecting the qadi's failures.
Le qadi est un juge unique investi dans ses fonctions par l'autorité publique en vue de trancher différentes sortes de conflits s'élevant entre les membres de la communauté musulmane.
The qadi is a single judge invested in his functions by the political authorities to solve various disputes arising between members of the Muslim community.
Il est nécessairement d'obédience musulmane et de sexe masculin.
He is compulsorily a Muslim and male.
Il est désigné à ce poste eu égard à ses vertus religieuses, ses connaissances de la loi divine et l'exemplarité de sa conduite sociale qui doit toujours être en conformité avec les prescriptions charaïques.
He is appointed for his religious virtues, his knowledge of divine law, and his exemplary social behavior, which must always abide by Sharia prescriptions.
La mission du qadi en terre d'islam est de résoudre le litige au regard de la sharia, tel qu'expliqué et interprété dans les ouvrages du fiqh.
The qadi's mission in Islam is to settle disputes according to Sharia, the divine law, as explained and interpreted in the fiqh.
Les ouvrages du fiqh rédigés par les jurisconsultes musulmans et dans le corpus global constituent ce que l'on appelle le droit musulman.
which is I'm sorry, vous pouvez répéter s'il vous plaît?
Oui. Ces ouvrages du fiqh sont rédigés par les jurisconsultes musulmans et dont le corpus global constitue ce que l'on appelle le droit musulman.
So what makes up the fiqh is written by by Muslim jurists and put together they constitute the corpus of what is Muslim law.
Élément important, le qadi n'applique pas un droit étatique, mais un droit de type doctrinal consigné dans les ouvrages des jurisconsultes musulmans, un droit présenté comme ayant un caractère religieux car dérivant des sources sacrées.
The qadi does not apply a state law, but a doctrinal type of law recorded in books by Muslim jurists. This law is supposed to have a religious dimension as it comes from holy sources.
En somme, le qadi est celui qui rend justice en mettant en pratique l'ordre divin. Relié à la charia, la fonction de juger apparaît comme une fonction à haute intensité religieuse.
In short, the qadi is the one dispensing justice by enforcing divine order. As it is linked to Sharia, the function of judging has a high degree of religiosity.
Nommé dans ses fonctions par le pouvoir politique, le juge musulman était amené à rendre compte de ses manquements à la charia devant ceux qui l'ont désigné.
Appointed by political authorities, a Muslim judge had to account for his failures to Sharia to those who had appointed him in his functions.
À cette responsabilité terrestre du qadi se juxtaposait une seconde catégorie de responsabilité encore plus importante, dans la mesure où elle va marquer l'originalité de la fonction judiciaire chez les musulmans. Il s'agit de la responsabilité du qadi devant Dieu.
On top of these earthly responsibilities, a second, even more important type of responsibilities came upon the qadis to permanently mark the originality of the legal function in Islam, namely the qadi's responsibilities for his failures before God.
La conception musulmane de la judicature présente un particularisme qui consiste à conférer un aspect eschatologique à la fonction de dire le droit.
The Muslim conception of judicature has a specificity in that it gives an eschatological dimension to the function of dispensing justice. That is to say, a responsibility in the afterlife.
La peur de la sanction dans l'au-delà explique l'aversion manifestée par un certain nombre de jurisconsultes à l'égard de la judicature. La peur de la sanction dans l'au-delà explique l'aversion manifestée par un certain nombre de jurisconsultes à l'égard de la judicature.
The fear of the sanction in the afterlife explains the aversion quite a few jurists have for judicature.
La compétence du qadi est assez large. Sa mission est de rendre la justice conformément à la loi divine, et cette mission s'étendait à la matière civile, commerciale et pénale.
The qadi's jurisdiction is quite large. His mission is to dispense justice, establish justice between individuals in accordance with divine law, and this mission extended to civil, commercial and penal matters.
En cas de litige entre deux musulmans appartenant à deux rites différents, le choix du rite appartient au défendeur.
In the event of a dispute between two Muslims, the plaintiff has the choice for which right will be applied.
En cas de litige entre un musulman et un non-musulman, le juge compétent est le juge musulman. La règle étant qu'un musulman ne peut pas être jugé par un juge non-musulman.
In case of a dispute between a Muslim and a non-Muslim, the judge has to be Muslim, because the writer has to be Muslim, because a Muslim cannot be judged by a non-Muslim.
Les règles organisant la procédure devant le qadi sont rudimentaires.
The rules before the hadith are quite rudimentary.
Le qadi tranche en principe le litige opposant les parties de manière irrévocable.
The hadith usually settles the dispute irrevocably.
Le système procédural musulman ignore le principe du double degré de juridiction. Concrétisant la volonté du Dieu, la décision du qadi est sans appel.
The Muslim procedural system ignores the principle of double-layered jurisdiction, thus materializing the will of God. The hadith's decision is unappealable.
En somme, le système procédural musulman est un système peu formaliste et il y a très peu de règles de procédure. Et le peu de règles qui existent sont animées par l'esprit charaïque et des anciennes coutumes ayant cours traditionnellement dans le secteur judiciaire.
In short, the Muslim procedural system is little formalist. There are little procedural rules, and the few existing rules are animated, are driven by the Sharia spirit, the spirit of Sharia, and ancient customs traditionally still enforced in the judicial field.
Cette manière de rendre la justice que l'on vient de décrire correspond à la première période de l'islam. Elle va connaître des transformations au fil du temps.
The way justice was dispensed, as we have just described, corresponds to the first period, the first epoch of Islam, and it will be subject to changes over time.
Le 19e siècle constitue une période charnière qui annonce un début de rupture par rapport au passé.
The 19th century was a pivotal time period, which was the beginning of a break from the past.
À la faveur des réformes amorcées au sein de l'Empire ottoman, qu'on appelle les Tanzimet, on assistera à l'apparition en Turquie des premières juridictions séculières, les juridictions nizamiya.
With the reforms which took place in the Ottoman Empire, called the Tanzimat, we then start the first secular jurisdiction started to appear in Turkey. They were called the Nizamiya jurisdictions.
Les juridictions nizamiya, oui. Ces juridictions viennent restreindre les champs traditionnels de la compétence du qadi dans les domaines civil, commercial et pénal.
These jurisdictions restricted the traditional field of jurisdiction of the qadis in civil, commercial and penal matters.
Fait important, la mise en place de ces juridictions séculières est assortie de l'adoption de codes de procédure.
An important fact was that the implementing of those secular jurisdictions came with the adoption of procedural codes.
Code de procédure civile en 1861.
The Civil Procedure Code in 1861.
Et code de procédure civile et commerciale. Et code de procédure pénale en 1879.
And a civil code of commercial procedure and a code of penal procedure, criminal procedure in 1879.
Ces codes de procédure reprennent pour l'essentiel des solutions adoptées dans ces différentes matières en droit français.
These procedural codes mainly resume solutions adopted by the various in these various matters by French law.
On assiste ici à une prise en charge par l'État de l'organisation de la procédure au regard de modèles et de règles importés d'Occident.
So what we see here was the state becoming in charge, being put in charge of the organization of procedure with regards to models and rules imported from the West.
Ce même phénomène est observable en Égypte.
This same phenomenon was observed in Egypt as well.
En 1876, sont instaurées les juridictions mixtes.
And mixed jurisdictions were implemented in 1876. Sorry.
Ces nouvelles cours de composition égypto-étrangère étaient chargées de trancher les litiges qui s'élevaient entre des personnes de nationalités différentes en application d'un droit moderne.
These new courts of law, which were both Egyptian and foreign, were in charge of settling the disputes arising between people of different nationalities, applying modern law.
La mise en place de ces cours est accompagnée par la promulgation de 2 codes de procédure, le code de procédure civile et commerciale et le code de procédure pénale.
Implementing these courts came along with the promulgation of 2 procedural codes, the Civil Procedural Code and the Civil and Commercial Procedural Code and the Code of Criminal Procedure.
Ces codes étaient également d'inspiration française.
And these codes were also inspired by French law.
Ce phénomène de sécularisation de la justice et de la procédure était également observable au XIXe siècle en Tunisie, pays qui à l'époque était sous colonisation française.
This phenomenon of secularizing justice and procedure could also be observed in Tunisia in the 19th century, and back then Tunisia was colonized by the French.
Ce mouvement de sécularisation va s'accentuer au XXe siècle avec l'accès de nombreux pays arabes à l'indépendance.
This secularization movement accelerated in the 20th century when many Arab states gained their independence.
Ce mouvement est animé par le souci de ces pays de se moderniser.
And this movement was motivated by the wish, the desire these countries had to modernize themselves.
C'est dire qu'on assiste aujourd'hui à un vaste mouvement de sécularisation du droit judiciaire privé dans les pays arabes.
Therefore, today, we are seeing a double movement for secularization of judicial law, private judicial law in Arab states.
Cette sécularisation obéit à un double mouvement, un reflux et un alignement.
This secularization undergoes a double movement, reflux and alignment.
Un reflux du modèle traditionnel, religieux, qui est relié par un alignement sur un modèle laïque tourné vers une finalité objective, la bonne administration de la justice.
A reflux of the traditional religious model, which is taken over by aligning on a lay model, aiming at an objective goal, which is the sound dispensation of justice.
On trouve dans ce mouvement l'empreinte certaine du droit français. Cette première source de sécularisation va être consolidée par l'apport des droits fondamentaux.
The mark of French law can definitely be seen in this movement. This first source for secularization was consolidated by the input of fundamental rights.
Toutefois, ce mouvement général de sécularisation des normes du droit judiciaire privé ne saurait occulter certains îlots de résistance qui s'illustrent dans l'organisation du contentieux du statut personnel dans certains États arabes multicommunautaires.
Nevertheless, this general secularization movement of norms, of standards of private judicial law cannot hide a few areas of resistance which reveal themselves in the organization of personal status disputes in some multi-communitary Arab states.
Tout d'abord, le mouvement général de sécularisation des normes du droit judiciaire privé dans les pays arabes. Afin de cerner ce mouvement général, il convient tout d'abord d'en voir les manifestations pour essayer d'explorer par la suite quelques éléments d'explication de ce phénomène.
First, the general secularization movement of these private judicial law standards in Arab states. In order to grasp this general movement, we should first start by observing its manifestations, to then explore a few elements of to explain this phenomenon.
Ce mouvement de sécularisation affecte l'ordre judiciaire aussi bien sur le plan de la forme que sur le plan du contenu.
This secularization trend affects judicial order, both in its shape as in terms of its contents.
À la faveur de l'influence du droit français, tous les droits des pays arabes ont opté pour la codification du droit de la procédure civile.
Subjected to the influence of French law, all Arab states law chose to codify their law of their civil procedural law.
Ce mouvement général de codification s'efforce d'assurer une rationalisation de la procédure ainsi qu'une prévisibilité des normes applicables en la matière.
This general codification movement endeavors to ensure rationalization of procedure as well as the possibility to foresee enforceable standards in the matter.
Ce mouvement confirme une prise en charge définitive par l'État de la procédure dans ses infimes détails.
This movement confirms a definite permanent responsibility of the state in terms of procedure in its most intimate details.
Même un pays comme l'Arabie saoudite a opté pour la codification de sa procédure civile alors même que son droit civil ne l'est pas.
Even Saudi Arabia chose this, even though its civil procedure is not.
Sur le plan du contenu, l'organisation judiciaire dans les pays arabes a connu de grandes mutations. Tout d'abord, la mutation concernant la détermination de la compétence des tribunaux étatiques et ensuite une mutation concernant l'agencement de la hiérarchie de ces juridictions.
The legal organization in those Arab states underwent great changes, which show both in the determination of jurisdiction of state courts, as well as the hierarchical organization of those jurisdictions.
En ce qui concerne la compétence, dans les litiges internes, la compétence du juge est déterminée par la conjonction des règles de compétence d'attribution et des règles de compétence territoriale.
In terms of domestic disputes, a judge's jurisdiction is determined by a conjunction of appointment for jurisdiction rules as well as territorial jurisdiction rules.
Concernant les litiges internationaux, les critères de compétence du juge national sont fixés de manière générale par des règles intégrées au sein des codes de procédure civile.
Regarding international disputes, the criteria, the national judges' jurisdictions criteria are set pursuant to rules usually integrated within civil procedural codes.
Dans ce contexte, seule la Tunisie fait figure d'exception puisque les règles relatives à la compétence internationale de ces tribunaux sont consignées dans un code de droit international privé.
In such a context, only Tunisia is an exception, since the rules relating to international jurisdiction of its courts are recorded in a private international law code, which was adopted in 1998.
À une hiérarchie quasi inexistante, on assiste aujourd'hui, depuis la codification de la procédure civile dans les pays arabes, à un agencement cohérent de la hiérarchie des juridictions étatiques.
To almost non-existent hierarchy, we have been seeing a coherent organization of the
Hiérarchie.
Pardon?
La hiérarchie des juridictions.
We have been seeing a coherent organization of the hierarchy of state jurisdictions since the codification of the civil procedure.
Cette hiérarchie est animée par deux grands principes, le principe du double degré de juridiction et le principe du pouvoir de régulation de la Cour de cassation.
Two major principles motivate this hierarchy. The first one is the principle of the double-layered jurisdiction, and the second one is the principle of regulating power the Supreme Appeal Court has, which is the Court of Cassation.
Inconnu dans le système traditionnel, le principe du double degré de juridiction est repris par tous les systèmes de procédure des pays arabes.
Though it was unknown in the traditional system, the principle of double-layered jurisdiction was integrated in all procedural systems in Arab states.
Certains pays l'ont même constitutionnalisé. Ainsi, l'article 108 de la Constitution tunisienne affirme que la loi garantit le principe du double degré de juridiction.
Some countries even went as far as making it part of their constitutions, as Article 108, paragraph 2 of the Tunisian Constitution, it states that the law guarantees the principle of the double-layered jurisdiction.
Le régime du pourvoi en cassation dans les systèmes juridiques des pays arabes emprunte très largement au système procédural français. La Cour de cassation est juge du droit et non un troisième degré de juridiction.
The system to be able to appeal in cassation, supreme appeal, in legal system in Arab states is very much inspired by the French procedural system. The Court of Cassation judges the right, and it is not a third level of jurisdiction.
Elle contrôle la bonne application de la loi et assure l'unification de l'interprétation qui lui est donnée par les juges du fond.
It controls the sound enforcement of law by judges, and it ensures the unification of interpretation, which is granted, which it has received by the judge, from the judges.
Sur le plan de l'organisation du procès, l'influence des normes étrangères laïques, droit français et droits fondamentaux, se situe tout d'abord au niveau des normes générales.
In terms of organizing a trial, the influence of lay foreign standards, French law and fundamental rights, first and foremost is we find the general standards giving a direction to the trial.
Des normes générales qui orientent le procès, lui donnent sa cohérence et assurent son organisation conformément à une certaine éthique.
These general standards, or giving an orientation to the trial, give the latter its coherence and ensure its organization, abiding by an ethical code.
L'influence, ensuite, se place sur le plan des règles de détail relatives au déroulement du procès.
Then this influence is exerted at the level of detailed rules relating to the taking place of the trial.
En ce qui concerne les normes générales relatives à l'organisation du procès, les droits de la procédure dans les pays arabes consacrent largement la notion de procès équitable.
Regarding those general standards relating to the organization of a trial, procedural rights in Arab states
Consacrent les droits de la procédure. Les droits de la procédure.
They really confirm the notion of a fair trial.
Yes. Cette notion combine deux éléments, le droit au juge et les droits de la défense, au premier rang desquels figure le principe du contradictoire.
This concept combines two elements, the right to a judge and the right of the defense, and the main one is the contradictorial principle.
En ce qui concerne les règles de détail relatives au déroulement du procès, on retrouve ici l'impact du droit français. Les droits arabes de la procédure adoptent dans ce contexte les différentes séquences du déroulement du procès civil.
Concerning the detailed rules concerning the taking place of a trial, what we find here is the influence of French law. Arab procedural rights adopt the different sequences of the taking place of a civil trial in this context.
Des séquences qui sont bien connues du droit français, telles que la phase introductive d'instance, la phase de l'échange des conclusions, la phase de plaidoirie, de délibérer et de prononcer de la décision.
And these various stages are very well known in French law. They are the instance introductory phase, the exchange of findings, then the defense speech, then the findings, then the delivery of the decision.
Par ailleurs, on retrouve l'influence française dans l'articulation des décisions judiciaires, faits et procédures, motifs, dispositifs.
Moreover, we can find the French influence in the way these judicial decisions are articulated with facts and procedure, grounds, and operative parts.
Maintenant, il convient d'apporter quelques éléments d'explication à ce mouvement de sécularisation.
But we will now give a few elements to explain this secularization movement.
Dans ce contexte, l'histoire apporte un premier élément d'explication.
In this context, history gives a first element of explanation.
La modernisation qui s'est opérée dans le cadre des réformes ottomanes est une modernisation par le haut, et c'est précisément les trois ministres du calife ottoman, les ministres Rachid Becha, Ali Becha et Fouad Becha, qui sont ici les véritables importateurs des codes français.
The modernization which took place as part of the Ottoman reforms is modernization from above, top down. and with 3 ministers in particular, 3 ministers of the Ottoman Caliph, and these are ministers Rashid Pasha, Ali Pasha, and Fouad Pasha, who really were the importers of the French codes.
À la faveur de sa connaissance de la langue française et de son séjour à Paris, cette élite a été séduite par la culture juridique française dont l'aura dans le monde ne cessait de croître du fait du rayonnement du Code civil et des autres codes qui y sont subséquents.
Because they knew the French language and they had been to Paris, these people were seduced by the French legal culture, whose aura worldwide kept growing due to the blossoming of the French Civil Code and other subsequent codes.
Cette modernisation par le haut se vérifie également en Égypte.
And this modernization from the top was also observable in Egypt.
Province autonome de l'Empire ottoman, l'Égypte a toujours été d'un apport décisif dans la diffusion de la culture juridique française dans les pays arabes.
As an autonomous province of the Ottoman Empire, Egypt had always had a decisive input in the spreading of the French legal culture throughout Arab states.
La réflexion pourrait à première vue surprendre, tant et si bien que ce pays a été pendant des décennies sous occupation britannique.
At first sight, this could be surprising, up to the point that this country had been occupied by the British for decades.
Pour saisir les termes de ce paradoxe, il y a lieu de relever qu'un premier contact avec le droit français de la procédure a eu lieu lors de la campagne de Bonaparte en Égypte.
In order to grasp the terms of this paradox, we should remember that there had been a first contact with French procedural law during Bonaparte's campaign in Egypt.
Sans toucher au système juridique musulman en place, les Français avaient à l'époque introduit des innovations juridiques tenant à la création de tribunaux commerciaux mixtes où siégeaient de façon paritaire des commerçants musulmans et des commerçants non musulmans.
Without touching the
Muslim
legal system, which was in place already, the French then introduced legal innovations regarding the creation of mixed commercial courts in which Muslim tradesmen and non-Muslim tradesmen used to sit in equal proportions.
Bien que limitée dans le temps et dans son champ d'intervention, cette première expérience juridique française allait marquer les esprits. Elle est, selon Jean Goldberg, le point de départ de transformation des élites du droit.
Even though it is limited in time and its field of intervention, this first experience, French legal experience, was going to mark minds. According to Jean Goldberg, it was the starting point to transform law, the elites starting point to transform the legal system.
Transformation des élites du droit, c'est très important ce point-là. Dès 1920, les autorités égyptiennes vont envoyer des missions d'étudiants en France pour étudier le système juridique français, lesquels étudiants s'efforceront à leur retour en Égypte de reproduire le modèle étudié.
As soon as 1920, Egyptian authorities sent hordes of students to France to study the French legal system. And these students, when they came back to Egypt, endeavored to reproduce the system they studied.
Cette influence allait continuer par la suite et touchera de manière décisive dans les années 70 du 19e siècle la procédure avec l'adoption des codes mixtes de procédure civile et pénale.
This influence was going to continue and decisively affect the procedure in the 1870s with the adoption of mixed civil and penal procedure codes.
C'est dire au regard de ces éléments qu'au moment même où l'occupation britannique prenait place en Égypte en 1882, la tradition juridique française était déjà profondément ancrée dans ce pays et avait animé la majorité des réformes juridiques.
In light of these elements, it is we can really see that when the British occupation took place in Egypt in 1882, the French legal tradition was already quite deeply rooted in Egypt and had was already behind the majority of legal reforms.
Élément important à signaler, le droit égyptien est un droit qui est actuellement très largement diffusé dans les pays arabes. Par l'intermédiaire de ce droit, le droit français va circuler dans les pays arabes où il n'a pas pu exercer directement son influence.
Another important detail is that Egyptian law is currently very spread out in Arab countries, and through this law, French law is quite common in Arab states in those Arab states where it couldn't directly exert its influence.
Le fait colonial constitue un autre facteur qui explique l'influence française. En tant que puissance coloniale, la France a imposé son droit aux entités colonisées.
Colonization is another quite significant factor explaining the French influence. As a colonial power, France imposed its law to the countries it colonized.
À cet effet, elle a exercé une politique coloniale assimilationniste, contrairement à d'autres politiques qui ne sont pas assimilationnistes. C'est une politique qui cherche à intégrer les entités colonisées sous la grille juridique.
For that purpose, it exerted assimilationist colonial policy, seeking to integrate the colonized entities under the legal grid.
De ce point de vue, des pays comme la Tunisie, l'Algérie, le Maroc, la Syrie et le Liban ont subi directement des influences françaises au niveau de l'organisation judiciaire et du droit du procès.
From that point of view, countries such as Tunisia, Algeria, Morocco, Syria, and Lebanon directly underwent the French influence in terms of legal organization and of right to a trial.
Un autre élément d'ordre politique vient se juxtaposer aux facteurs historiques.
Another element of a political nature came on top of these historical factors.
La codification de la procédure a scellé définitivement le sort de l'étatisation du droit de la procédure et a assuré par là même une meilleure mainmise de l'État sur l'organisation de la justice et du procès.
The codification of the procedure permanently set the fate of the nationalization of procedural law, and it also ensured a better grasp by the state on the organization of justice and trials.
Le modèle de droit codifié à la française, qui est dirigiste, permettait un plus grand contrôle du système judiciaire que celui de la common law, qui laisse une plus grande marge de manœuvre aux juges.
The codified legal system à la française, which is very directive, allowed a greater control of the legal system as that of common law, which gives wider maneuver possibilities to the judge.
Ce dirigisme étatique en matière de procédure correspond donc à de jeunes États-nations en quête primordiale d'une complète maîtrise de leur ordre juridictionnel.
This state authority in terms of procedure therefore is more characteristic of young states who are after a complete control of their jurisdictional orders.
Ce mouvement de sécularisation va être renforcé par l'essor des droits fondamentaux.
This secularization movement was reinforced or strengthened by the blossoming of fundamental rights.
De nombreux pays arabes ont adhéré à des textes à caractère universel relatifs aux droits de l'homme qui adoptent expressément la notion de procès équitable, telle que la Déclaration universelle des droits de l'homme ou encore le Pacte international des droits civils et politiques.
Many Arab states adhered to these texts with a universal dimension and relating to human rights, and they explicitly, expressly adopted the notion of a fair trial, such as the Universal Declaration of Human Rights and the International Pacts for Civil Rights and Policies.
Ainsi, la consolidation du mouvement de sécularisation dans les pays arabes se fait ici par le relais de la notion de procès équitable consacrée dans les textes internationaux relatifs aux droits de l'homme.
Strengthening this secularization movement in Arab states took place, in that case, took place through the continuity with the notion of a fair trial, which was written in international texts relating to human rights.
Toutefois, ce mouvement connaît une résistance. Ce mouvement de sécularisation connaît une résistance qui se révèle dans l'organisation du contentieux du statut personnel dans les États arabes multicommunautaires. La résistance au mouvement de sécularisation.
Yet, this secularization movement was despite this secularization movement, which the Arab states judicial law underwent, there were areas for resistance to this phenomenon, and these showed in the organization of the personal status dispute in multi-communitary states.
En droit musulman, les rapports de coexistence entre les musulmans et les non-musulmans monothéistes étaient régis par le pacte de la Dhimma. Oui.
In Muslim law, the coexisting, the relationships to coexist between Muslims and non-Muslims, monotheist non-Muslims, were regulated by a pact called Pact of the Dhimma.
En vertu de cet accord, les autorités politiques musulmanes habilitaient les communautés monothéistes non musulmanes à soumettre leurs propres litiges de statut personnel à leur propre juridiction qui leur appliquait leurs propres lois en la matière.
In light of this, pursuant to this agreement, Muslim political authorities authorized monotheistic non-Muslim communities to bring their own disputes, personal status disputes, to their own jurisdictions, which applied their own laws in that respect.
Dans ce système, la communauté musulmane se trouvait soumise aux juges charaïques qui appliquaient le droit musulman.
In this pluralistic system, the Muslim community was subjected to the Sharia judge who enforced Muslim law.
La communauté chrétienne était soumise à ses propres juridictions qui leur appliquaient le droit canonique et la communauté juive était soumise aux tribunaux hébraïques qui lui appliquaient la loi israélite.
The Christian community was subjected to its own jurisdictions, applying canon law. And lastly, the Jewish community was subjected to Jewish courts enforcing Jewish law.
Dans le domaine du statut personnel, on assiste actuellement à des survivances de cette organisation judiciaire pluraliste dans certains pays arabes multicommunautaires.
We can see that we can observe surviving. We can see that this legal organization, pluralistic legal judicial organization, is surviving in some multi-communitary Arab states.
C'est des pays qui comprennent au sein de leur population des communautés originaires non musulmanes.
In these countries, we can find native non-Muslim communities.
Nous allons prendre ici deux exemples, l'exemple libanais et l'exemple égyptien.
We are going to now see two examples, Lebanon and Egypt.
Au Liban, il y a 18 groupements confessionnels qui sont reconnus par l'État.
In Lebanon, there are 18 religious groups recognized by the state.
Les communautés chrétiennes sont au nombre de 12. Oui, allez-y.
There are 12 Christian communities.
Les communautés musulmanes sont au nombre de 5.
5 Muslim communities.
À ces 17 communautés, il faut ajouter la communauté juive.
And on top of these 17 communities, there is also the Jewish community.
Chaque groupe confessionnel est soumis à ses propres juridictions qui lui appliquent ses propres lois en matière de statut personnel.
Each religious group is subjected to its own jurisdictions, applying its own laws in terms of personal status.
Mais il y a des différences entre les juridictions musulmanes et les juridictions non musulmanes.
But differences exist between Muslim communities and non-Muslim communities.
En ce qui concerne les communautés musulmanes, il faut savoir que l'État libanais abrite dans son appareil judiciaire les tribunaux musulmans qui constituent l'une des branches de la justice étatique.
The state of Lebanon has Muslim courts in its legal apparatus, making up one of the branches of state justice.
Les juges des tribunaux musulmans sont des fonctionnaires payés par l'État et soumis au contrôle du ministère de la Justice.
Judges in Muslim courts are employed by the states, civil servants, and they are under the control of the Ministry of Justice.
La compétence des tribunaux religieux musulmans en matière de statut personnel est plus large puisque, à la différence des juridictions religieuses non musulmanes, cette compétence intègre les successions.
Jurisdiction of Muslim religious courts in terms of personal status is wider because unlike non-Muslim religious jurisdictions, this jurisdiction encompasses successions.
La procédure devant les tribunaux musulmans, sunnites et chiites, est détaillée en vertu d'un texte du 16 juillet 62.
Procedure before Sunni and Shiite Muslim courts is detailed pursuant to a text dating from the 16th of July 1962.
En ce qui concerne l'organisation des communautés non musulmanes, il faut savoir que l'organisation et le fonctionnement de leurs tribunaux relèvent de leur propre autorité.
Regarding the organization of non-Muslim communities, the organization and running of their courts are their own responsibility and authority.
Celles-ci fixent les règles de fonctionnement de leur justice ainsi que la procédure qui gouverne le déroulement de l'instance.
These authorities set the rules to function, to run of their justice, as well as the procedure ruling over the instance itself, the way it unfolds.
Le droit substantiel applicable aux relations de statut personnel émane également des autorités communautaires.
Substantial law applicable to personal status relationships also comes from these communitary authorities.
Les juges appartiennent nécessairement aux membres de la communauté religieuse concernée et ne sont pas intégrés à l'appareil étatique.
Those judges have to be members of the religious community in question and are not integrated to are not civil servants employed by the state.
À la différence des juges musulmans, ils ne sont pas des fonctionnaires de l'État libanais et relèvent au niveau de leur rémunération des communautés religieuses.
Unlike Muslim judges, they are not employed by the state of Lebanon, and their remuneration, their payment, is the affair of the religious communities in question.
En vertu de l'article 95 du Code de procédure libanais, l'Assemblée plénière de la Cour de cassation est compétente pour connaître des oppositions formulées à l'encontre des décisions rendues par les tribunaux religieux musulmans ou les tribunaux religieux non musulmans.
Pursuant to Article 95 of the Code of Civil Procedure from Lebanon, the plenary assembly of the Court of Cassation has jurisdiction to receive oppositions expressed against the decisions given by Muslim religious courts or non-Muslim religious courts.
Cela peut avoir pour objet l'incompétence de ces tribunaux, ces recours sont faits en raison de l'incompétence de ces tribunaux ou encore en raison de leur violation de l'ordre public.
These can be due to the non-jurisdiction of those jurisdiction, or also because they are infringing public order.
Toutefois, ce contrôle de l'ordre public va être exercé de manière très lâche par la Cour de cassation libanaise de crainte de heurter les susceptibilités des communautés religieuses.
Yet, concretely, this control is exercised very freely by the Lebanese Court of Cassation for fear of hurting the susceptibility of the various religious communities.
Sous l'angle du droit judiciaire privé, on retrouve tous les maux qui rangent le Liban d'aujourd'hui. sous l'angle du droit judiciaire privé, on retrouve tous les mots MAUX qui rangent le Liban d'aujourd'hui.
We find all the plagues affecting today's Lebanon. We find je suis perdu, vous pouvez reprendre s'il vous plaît.
L'organisation judiciaire en matière de statut personnel est symptomatique de tous les maux qui rangent le Liban aujourd'hui.
The legal organization in terms of personal status is revealing of the plagues affecting today's Lebanon.
Des communautés religieuses qui font prévaloir l'intérêt communautaire sur l'intérêt général.
Religious communities who have their community interest over the general interest.
Et un État impuissant à l'égard des communautés, un État incapable de jouer son rôle d'unification du droit du statut personnel.
And a state which is unable to act over communities, a state incapable of playing its part to unify over the personal status law, in terms of personal status law.
Le second exemple que je vais vous donner est celui de l'Égypte, qui diffère un peu au niveau de l'organisation judiciaire du Liban.
And the second example we're going to see now is Egypt, which is slightly different from Lebanon.
À la différence du droit libanais, la loi égyptienne de 1955 a unifié la justice libanaise. Donc, on a un juge civil qui va connaître des litiges du statut personnel, quelle que soit la confession des litigants.
Unlike Lebanese law, law number 462 of 1955 unified Egyptian justice, and from then on, it has jurisdiction to solve all disputes relating to personal status, regardless of the community or the religion of the people brought before justice.
Toutefois, cette unification de la justice et de la procédure n'est pas relayée par l'unification de la loi applicable au fond en matière de statut personnel.
Yet, this unification of justice and procedure is not followed by a single enforceable law in terms of personal status.
Ainsi, les Égyptiens musulmans sont soumis à leurs propres règles du statut personnel qui sont largement inspirées du droit musulman.
Therefore, Muslim Egyptians have their own personal status rules, which are widely inspired from Muslim law.
Par ailleurs, il existe 14 groupes religieux non musulmans qui sont chacun soumis à ses propres juridictions, qui chacun est soumis à sa propre loi de statut personnel.
There are 14 groups of non-Muslim Egyptians, and they have their own laws and personal status.
Au-delà de l'unification de la justice et de la procédure, c'est-à-dire qu'on a un juge civil, le système égyptien connaît une dissociation inédite entre la compétence juridictionnelle et la compétence législative.
Beyond the unification of justice and procedure, the Egyptian system is faced with an unprecedented dissociation between actual jurisdiction and legislation.
Dans les rapports impliquant les communautés non musulmanes, le juge égyptien, juge étatique, va appliquer un droit non étatique. Il s'agit d'un droit confessionnel spécifique à un groupe religieux vivant sur le territoire de l'État égyptien.
In the relationships between non-Muslim communities, the Egyptian civil judges who are state employed, enforces a non-state law. That is to say, a religious law specific to a religious group living on Egyptian soil.
Ce pluralisme législatif à coloration religieuse soustrait à l'État le monopole de la production normative sur le terrain du statut personnel.
This legislative pluralism with a hint of religion takes away the monopoly of normative production from the state in the domain of personal status.
Ce qui emporte des contradictions flagrantes au niveau du droit substantiel appliqué en la matière.
Which brings blatant contradictions in terms of substantial rights law applied here.
Les communautés musulmanes connaissent la polygamie.
Muslim communities have polygamy.
Les communautés chrétiennes n'ont que la monogamie.
Whereas Christian communities have only monogamy.
Les communautés musulmanes connaissent la répudiation.
Muslim communities can exert repudiation.
Les communautés catholiques ne peuvent pas divorcer.
Catholic communities cannot get a divorce.
Inégalité successorale pour les musulmans.
Inequality of succession for Muslims.
Égalité successorale pour les communautés chrétiennes, etc. etc.
Equality of succession for Christian communities, etc.
Cette touche religieuse qui affecte l'organisation affaiblit la cohérence globale du système juridique.
This religious dose weakens the whole system.
Et la modernité de l'État s'en trouve sensiblement affectée.
And the modernity of the state is therefore significantly affected.
Je vous remercie pour votre attention.
Thank you for your attention.
Merci vivement, Monsieur Huillet, d'avoir relevé le redoutable défi de la traduction consécutive du français vers l'anglais, surtout lorsqu'il y a mot et mot. Merci, cher Samy, pour cet exercice difficile de droit judiciaire privé comparé, qui montre bien la tension à la fois historique, politique et culturelle entre la tradition, avec le droit religieux, spécialement en matière de statut personnel, et la modernité, avec le droit laïque, hérité pour partie du colonisateur, directement ou indirectement, via l'administration ottomane ou le droit égyptien, puis par la suite ouvert à l'essor des droits fondamentaux, avec le droit au procès équitable. Alors, je ne doute pas que cet exposé engagé a inspiré nos auditeurs, suscité bien des interrogations, mais nous avons perdu beaucoup de temps et nous n'avons guère de place que pour une ou deux questions seulement. J'en suis navré. Alors, qui souhaite poser cette ou ces deux questions, faire ce ou ces deux commentaires? J'ouvre la discussion pour quelques minutes. Je vous prie de bien vouloir m'en excuser. Je crois que j'ai refroidi tout le monde.
Enrique.
Enrique.
Well, thank you so much. To me, it's very, very interesting indeed. Thank you so much, Professor. I'm just curious about this process of secularization that you've been describing. And I would like to know if you could briefly explain how the role of the judge, being very linked to religion and being a religious figure, a male Muslim, as you put it at the beginning of your presentation, how the role of the judge has evolved in this process of secularization, whether it has been moving also to a more secular figure, female maybe in some countries. Thank you.
Professeur, vous voulez que je le traduise?
Oui, juste.
Please,
Oui.
if you can translate.
Ok, donc l'intervenant demande si vous pouvez parler de l'évolution du rôle du juge, du CRADI, avec le temps et à travers ce mouvement de sécularisation. Est-ce que par exemple ça a évolué en des juges de sexe féminin, peut-être dans certains pays, etc.
Oui, précisément, il y a un grand mouvement de féminisation du corps de la justice. Il y a un grand mouvement de féminisation du corps de la justice, mais c'est surtout, il y a plusieurs phénomènes qui expliquent ces transformations. Tout d'abord, il y a...
So yes, there is quite an important, quite significant trend of feminization of justice, and we're going to see a few examples of this.
Alors, les grandes transformations, et je l'ai signalé à plusieurs reprises dans mon intervention, c'est tout d'abord l'étatisation du droit qui n'existait pas. Alors,
the first one is the nationalization by the state, which didn't exist before.
Parce que la procédure était régie par des règles très sommaires, des règles rudimentaires.
Because before, the procedure was ruled by very rudimentary procedures.
Donc, il y a cet aspect du phénomène. L'autre aspect qui a totalement disparu, bien sûr, c'est que le juge est maintenant encadré par des codes étatiques de procédure civile, et l'une des singularités de la judicature en terre d'islam, qui est la dimension eschatologique, a totalement disparu. La peur de l'au-delà a totalement disparu. Donc, on assiste...
And the other big thing is that the judges are now framed, they are part of the state national apparatus, and the fear of the afterlife has completely disappeared.
Après, il y a des pays, notamment les pays où la justice n'est pas unifiée, où le qadi existe toujours.
In some countries where justice hasn't been unified, the qadi still exists.
Par exemple, au Liban, les tribunaux religieux musulmans, il y a un juge unique qui statue conformément à des dispositions du droit musulman classique. Donc, le qadi unique existe encore, mais sa compétence n'est plus une compétence universelle, c'est-à-dire qu'il ne va plus du civil, il ne va plus du pénal, il ne va plus du commercial. Donc, il y a juste le statut personnel de sa propre communauté.
For instance, in Lebanon, in Muslim Muslim religious courts, the qadi still exists, but his jurisdiction has narrowed quite a lot because he only has jurisdiction over personal status matters.
Merci beaucoup. Beleg El-Balti wants to put a question. Beleg, you have the floor.
Oui, merci. D'abord, je suis très content de revoir M. Semi Boustadji, qui était mon professeur à l'Université de Tunis. Donc, je suis très content d'intervenir après sa présentation admirable. Juste un petit commentaire, une petite question en fait. J'aimerais bien savoir qu'est-ce qu'il pense de l'influence du droit français. Apparemment, c'était l'un des piliers de son intervention, c'est la grande influence du droit français dans la région. J'aimerais bien savoir qu'est-ce qu'il pense de le recul de cette influence qu'on voit dans un certain nombre de pays de Golfe, avec ce qu'on appelle l'émergence des cours internationales commerciales, qui, elles, n'ont pas adopté le modèle français mais plutôt on regardait vers le côté de common law. Les juges sont common law, la procédure est common law, la langue est anglaise et tout ça. Donc, si vous avez une petite idée sur cette question, ça permettrait de mettre un peu de nuance sur l'influence du droit français dans la région. Merci beaucoup. Je suis très content de vous revoir.
Merci beaucoup. Monsieur Huillet, s'il vous plaît.
The question is, what do you think of the fact that French law is on the wane, especially in countries in the Gulf, where specifically commercial courts have an English influence or Anglo-Saxon influence because the system is common law, the language is English, etc.
Merci pour cette pertinente question. Vous savez, j'avais une demi-heure qui était dupliquée par une autre demi-heure, donc je ne pouvais pas vraiment présenter les détails, j'ai présenté les grandes tendances, mais c'est vrai qu'au cours de ces années, on assiste à une certaine américanisation du droit. Il y a une certaine américanisation du droit qui se traduit notamment par la reproduction de schémas d'organisation judiciaire anglo-saxonne, parce que les agents économiques, précisément, qui évoluent dans ces pays du Golfe, sont à majorité des Anglais et des Américains, et donc ils aiment... Oui.
Thank you for this very good question, and you are quite right. French law is receding, and nowadays what we see is some sort of Americanization of what happens in the countries in the Gulf, and the main reason for this is that the economic interests are Americans or Anglo-Saxons.
Oui. Donc en fait, c'est une manière aussi d'attirer des agents économiques et des investisseurs que de créer un effet d'affichage, à travers la reprise de modes d'organisation judiciaire anglo-saxonne. D'autant plus qu'il faut l'avouer, beaucoup de ces techniques sont des techniques qui sont très pragmatiques et qui correspondent parfaitement aux attentes et aux besoins des agents économiques aujourd'hui. Vous savez, dans les pays de Golfe, et jamais...
The fact is that yes, the fact that they install well, the facade becomes American also matches really well the economic interests. And j'ai un peu perdu le fil, je suis désolé.
Bon, je voulais juste ajouter un élément par rapport à ce qui se passe dans les pays de Golfe, et j'allais en parler, c'est que nous avons assisté au mois de novembre 2021 à l'adoption d'une loi qui est unique. J'allais en parler, mais j'ai été rattrapé par le temps, précisément à l'Émirat d'Abu Dhabi.
In November 2021, a law was adopted in Abu Dhabi, which I was going to mention, but we didn't have time.
Alors, c'est une loi qui régit le statut personnel des étrangers domiciliés à Abu Dhabi.
This law is rules over the personal status of foreigners domiciled in Abu Dhabi.
Et il y a une institution qui est consacrée, c'est un tribunal qui est instauré à Abu Dhabi, qui peut être présidé par un non-musulman, qui va statuer sur le statut personnel des étrangers non musulmans établis à Abu Dhabi.
And it's a court in charge of this, and a non-Muslim can actually preside this court, ruling over the personal status of foreigners settled in Abu Dhabi.
Fait unique dans le monde arabe, la procédure est en langue arabe et anglaise, alors que dans tous les pays arabes, la procédure est en langue arabe.
Throughout the entire Arabic world, the procedure always is in Arabic language, whereas there in Abu Dhabi, and this is completely unique, the procedure is both in Arabic and English.
Alors, l'autre grand paradoxe de ce système, c'est qu'on se trouve devant des solutions qui sont totalement à l'opposé du statut personnel régissant les Émiratis.
And another paradox is that this system is completely the opposite of the personal status applying to Emirati citizens.
Égalité successorale, possibilité pour la femme de divorcer,
Equality of succession, possibility for women to get a divorce,
garde partagée entre les deux époux, etc., etc.
Shared custody of a child between two spouses, etc.
Alors, c'est le même État qui produit des règles discriminatoires à l'égard de ses ressortissants et des règles libérales à l'égard des investisseurs et des agents économiques étrangers. C'est un peu le droit du statut personnel au service de l'économie de marché.
The result is that the state produces a discriminatory law against its own citizens and liberating or more liberal law for foreigners, and basically it's justice at the service of economic interests.
Voilà.
Bien, merci à vous trois pour cet intéressant excursus. Elena Jutova put a question on the chat. Monsieur le professeur, si j'ai bien compris, vous n'êtes pas d'accord avec le système de diversité des règles dans le statut personnel. Quelle solution recommanderiez-vous? You don't agree with the system of diversity of rules in the personal statute. What solution would you recommend?
En fait, en l'état actuel, je pense qu'il n'y a pas de solution. Du moment que l'État, vous savez, la définition de l'État moderne est un État de droit.
For now, there is no solution. The definition of the modern state is a state of law.
Et la notion d'État de droit est une notion qui est complexe.
And this concept is a complex one.
Parce qu'elle ne veut pas uniquement dire que les ressortissants, les personnes qui se sont assujetties au droit, elle veut... Oui.
It doesn't just say that the nationals are subjected to the law,
mais elle veut aussi dire, et ça on a tendance à l'oublier, que l'État a le monopole de la production du droit.
But it also says, and this is something we usually forget, it also says that the state has the monopoly of producing law and rights.
Donc, l'État au Liban, par exemple, est un État qui est pris entre 18 communautés. Il essaie d'assurer un équilibre impossible au point qu'il se trouve incapable d'unifier le statut personnel. Il se trouve incapable d'unifier le statut personnel et ça a été une revendication constante sur le plan politique d'une frange progressiste de la population libanaise. Donc, qu'est-ce que je recommande? Je pense qu'en l'état actuel, et vu les forces en présence, l'idée d'un statut personnel unifié ne me semble pas assez proche.
For instance, in Lebanon, with those 18 groups it has to face, to deal with, the state simply is incapable of playing that part. Et j'ai perdu le fil de la suite, vous avez dit.
Donc, vu la situation actuelle, l'État n'est pas en mesure d'imposer un statut personnel unifié parce que l'État est faible.
And because the state is weak, it is completely incapable of enforcing, creating a single personal status.
Voilà, bah écoutez, je crois qu'il est vraiment l'heure maintenant de clore cette passionnante réunion.
Thank you for thank you. It is time now to come to an end.
Merci. Merci.
Merci à toutes et à tous pour leur participation à ce 8e webinaire, nos orateurs, bien sûr, tous les auditeurs qui ont enrichi la discussion de leurs questions ou de leurs commentaires, Mesdames Trouet et Gellering pour l'organisation de cette session, ainsi que, bien sûr, notre interprète.
Merci. Merci, Monsieur Huillet.
Merci à vous, c'était un plaisir.
Merci.
Avant de se quitter, il me reste à vous informer que le prochain webinaire aura lieu le 1er avril. Il sera tout entier consacré à un sujet passionnant, celui des méthodes alternatives en droit comparé.
The next webinar will take place on the 1st of April, and the subject will be a new method of compared law.
C'est un éminent expert de ces questions qui nous en parlera, Russell Miller, qui est professeur à la Washington and Lee University School of Law en Virginie.
Russell Miller, who's an expert and a professor in law at the University of
Washington.
Washington.
Washington and Lee University School of Law. Voilà.
Will be the main speaker.
Yes. J'espère que vous pourrez y assister aussi nombreux qu'aujourd'hui. Et dans cette attente, je vous souhaite à toutes et à tous un très très bon week-end.
I hope you will all attend, and in the meantime, have all of you have a great evening.
Merci beaucoup.
Thank you very much.
Merci encore à vous deux, John and Sammy.
Merci.